Parkman, Mark Johnson, and the Dothan law firm of Parkman and White. Y'all have law firms in Dothan, Birmingham,
Working on opening an office in New York.
all over. That briefcase will travel.
Okay.
I want to talk to you a little bit about DUIs.
Okay.
I'm pulled over, just left Dothan Country Club and had a drink, and I get pulled over by the police. And they want me to get out and act like a monkey and stand on one foot and touch my nose. What do I do?
Well, my thing is you have to take each person individually. Some people don't have the dexterity that others do. So it's hard for them to get out and do some of the things because of their maybe an equilibrium problem or whatever they have. So if a person's athletic, if a person can do these things, then I suggest do them. I don't think there's anything wrong with it. I think it's good. I've won a lot of cases. Mark's won a lot of cases where we get the video and we actually see people, doing the things and that they're supposed to be doing. And supposedly this is an indication of whether you're intoxicated or not. If you have a problem, if you have an earache and there may be something wrong with equilibrium, or you're just not, you have a knee problem, you can't balance like you're supposed to, and you can't do those things, then don't do it. A lot of people say that they're built-in tricks. They tell you to hold a leg up and count until they get ready to stop you. Well, when is that stopping point? 1 or 1,000,000 till you fall over. So some of it's trickery, in my opinion, but the best thing to do is try to do what they try to say to do, if you can do it. If you can't, explain it to them. Tell them why you can't do it.
Absolutely.
Don't just say, I'm not doing that, but just explain it. There's nothing wrong with that.
And remembering everything you do is on video.
And remember, everything you do is on video, and what you say is on video. And you're gonna see that again.
When you get to the police station,
Yeah.
to take the test, my understanding you're already under arrest for DUI, even if you below 0. Do you take the test when you get to the police station?
All right. This has been an ongoing argument for years, and lawyers have different ways of looking at it, My viewpoint is I'd rather for you to take the test. Now let me tell you why. Number one is if you don't take the test, it's now, I think, an automatic loss of license for 90 to 180 days. On top of if you get convicted of the DUI. So you lose that for 90 days and you got another 90 to 180 for not taking the test. And they can do that because states that give licenses, states can revoke licenses. So they can do that. And that's a punishment for you not taking the test. I'd rather for you to take the test. Let me argue, if you've done pretty well on the balancing and on the walking and the things out in the field, your talking, how your speech is, what you say, I'd rather argue those things against what a machine tells you, especially a machine that they've got, that there are some discrepancies with the machine. So I'd rather fight that battle than I had you not taking the test. So that's my feeling. Mark?
Once again, it's hard to say, don't take it, take it. Let's use your example. If you've been at the country club and you knew you had only had one glass of wine or whatever, take the test. Take the field sobriety test. If you have a physical disability or any incapability that you think prevents you from doing the field sobriety test, make sure you make that officer aware of that, because once again, even if he chooses to ignore the fact that you told him that, it's on the video, it's on the tape. So therefore, if you can't do the one-legged stand or the walking turn to his satisfaction, what they're looking for is clues. They teach officers to look for certain clues or certain failure points, and you collect so many, and then you're deemed to fail the test. Okay, so once they do that, if you've given them advance notice of your deformity or your disability, I've got a wooden leg, I've got pins in my ankle, and I can't stand on this leg by itself, or I physically can't hold one leg up because I have very bad vertigo or equilibrium, like Jim said. Those are the things they need to know. Now, if he puts the cuffs on you and you're getting in the back of the car, well, then it comes down to, do I take the test at the jail? Once again, to me, it's an issue. If you're competent enough to know that you've only had one or two drinks, take it. But you're right. If it's close, they're going to take you to jail. If it's a .02, they're still going to take you. You may win it easier, but they can't just try to, don't wave a wand and unarrest somebody. Yeah. You've already been arrested. They don't have any choice but to put you in jail, maybe lose the case. But there are consequences for refusing to take the test. You'll hear a lot of attorneys argue that don't take the test under any circumstances because now we can just argue the officer's observations, your failure points on the test, as opposed to the instrument, which is deemed by the Department of Public Safety to be admissible in court and all this kind of stuff this results. But yet again, like Jim says, that instrument is not infallible. It has an error rating and it has monitoring issues and how often has it been checked and calibrated and all these kind of things that come into play. If you've been in an accident and they try to determine that you're intoxicated, well, you're probably not going to be able to do any field sobriety test if you have any type of injury. But if they, try to offer you a test, that's the situation where you may not be able to take it because if you got any facial injuries, any blood in your mouth or anything like that, that's going to cause a false reading or it's not going to work right, You need to make sure you tell them to take you to the hospital, that kind of thing. So it's somewhat circumstantial and it's hard to just pin it down. I agree with you.
I think what it boils down to is most people, again, placed in a situation involving stress, don't sit here and think through these things logically. They do what they think is best at the time, which may not be, but that's the pressure of the situation. You're standing out there, blue lights going, headlights in your eyes, police officers all around. They always bring 14 police cars. And so, they're all out there like you're, Parker or something that you had just robbed the banks downtown. So you're out there, you make a decision. What I'm trying to tell you, and I think what Mark's trying to tell you, we just have to deal with it after that fact. We have to deal with your decision. If it comes down to you being able to make a logical decision, then you should go ahead and take the test. Because if you can think like that, then you're probably not bad off. And finally, be nice.
Yes.
Now that sounds kind of silly, but you get a lot of people who drink, they change personalities. When you're stopped, they're a little more belligerent. It comes out. If you're nice, people are going to look at it in a different mode, especially on a jury.
I agree. One other thing, and talking about the instrument test at the jail, my opinion is the legislature is trying to legislate people into taking that test. They have increased the penalties for not taking it. When they redid this DUI stuff, I think it's to try to make people take it more because a lot of people are saying, I'm just not taking the test, So, I think that's a causation of why we got this legislation redone to increase the penalty for not taking it,
If I'm pulled over and I take the test and I disagree with the reading, can I request a blood test?
Yes.
Yes.
What happens if they don't carry me to the jail, to the hospital?
Then the original test goes out the door. Now, you have to be in a position to pay for that test.
Correct.
That they don't bill that on the state dollar. So you need to be able to say, I want to go to the hospital, I want to take a blood test, I can pay for it. I want to do that.
As soon as you're released from jail, you need to contact.
You need to call while you're in there. As soon as they give you the chance to drop a dime, and get somebody down there to try to help you immediately before you get into any predicaments that you may not know about.
And people need to know if you get arrested for a DUI, they're going to hold you until you will eventually have to blow into the instrument to leave, called a jail exit test. So if you refuse the first test, you're not going to get out of jail till you blow at some point and you blow zeros. So they understand. Of course, they can't release anybody that's intoxicated. So people do say, well, they made me blow they wouldn't let me out till I did. Well, that's only because that's not a test that's really used against you evidentiary-wise, the zeros, but that's to be able to release you on bond. They have to make sure you're not going to be intoxicated.
How do we contact your law firm?
661 West Main, Parkman and White, right here in Dothan. 334-792-1900. We've got 2 websites, parkmanandwhite.com and dothanlawfirm.com. Feel free to review our websites. It's got information about all our cases, what we do, all the attorneys here at the office and the Birmingham office, and the numbers to be reached at.
Thank you.